Good day, fellow South Africans. I am just busy with the administrative issues from court and then wish to inform you of the proceedings that have taken place yesterday on 24 August 2021. Yesterday, myself and counsel representing the other 7 defendants in the matter before the Western Cape High Court to case numbers 19275 of 2020, in which Lieutenant Commander Sylvester Mangolele is the plaintiff, and the state is the first defendant. The President is the second defendant, the Minister of Defense is the third defendant, Chief of the South African Navy is the fourth defendant, Officer in Charge Lexato Cape Town is the fifth defendant, Mr. Marcel de Wet is the sixth defendant, Minister of Police is the seventh defendant, and the National Prosecuting Authority is the third defendant. And currently, right now, I am about to take a call. I'm in the office anyway. Mangolela, hello.
Hello?
Hello, how are you?
Good, and you?
I'm surviving, my brother.
Yes.
Yes, I tried to call you. I believe or you WhatsApp, or you are finding me currently live on this particular issue where I'm discussing the matter of your email that you've just sent, saying that you are no longer representing the SABC.
Yes.
May I ask, please, because I am currently having issues of getting the legal department of SABC, for you to revert to them and then inform them that, okay, as the last counsel on record, you have received this particular notice of motion, and then you request advice from them, and then maybe they will do their internal things, because I don't have the direct link of internally talking to them as you have.
I also doubt, because this matter was dealt with in 2018 or 2019.
Yeah.
That was my last matter with SAPC. So I don't know what is happening there and who to direct whatever comes across my way to.
No matter what I am saying is that in the manner at which they arrived at you, you may go retrospect. Say Uguti, maybe they arrived at you through person so. You may tell the same person so, that person so will know the relevant office that authorized your employment.
No.
That's all I'm asking.
The person that I dealt with was assassinated in 2019. Who was the head of legal of the SAPC. I will try, but the person that was head of legal who had instructed me on the matter passed on.
I am sorry to hear that.
Yeah, but I will see what I can do. But I mean, if they don't receive it, because I don't think that you are seeking any recourse against the SAPC.
No, not entirely. It will maybe come afterwards, yes. Just only for them to be informed of the standing matter where the opposition lies on this particular nature of Uguti. The matter is not in terms of the Section 21B of the Vexatious Proceedings Act, because the reality of the terms therein, they obligate the hearing of the person accused of such before the granting of an order. So that is the only issue that the presiding officer on the matter will have to make a decision on. Any other thing in the application is just only additional information directing her to the very same issue where we start from the beginning. You understand? Because if we cannot pass begin, we therefore cannot do this particular thing where one has to consider other terms following after the beginning part. You get what I'm saying? Yes. So that is my point of departure in the matter, and then that point is in terms of section 21B. It's not in terms of me, it's in terms of the act that is being employed in this current matter. But the action that is required from the court will be the rescission of the matter in terms of section 21C, which is also advanced as an applicable section in this particular matter. So it's a direct thing that doesn't actually require whatever that might be argued or that may ensue in record of court. You understand? So
no, it's fine. I will just try and see if I don't manage to link someone there, and then once I will then forward the papers. I think they will take it from there.
No, that will be much appreciated, my brother.
Okay, sir.
Other than that, thank you very much. I don't know about counsel of the other parties, Bona. They have not responded, and then but I will call them tomorrow morning in that regard during office hours. But I thank you very much for your understanding in this regard.
No, thank you, sir. That's
all right.
Pleasure.
Shaba then, Papa.
Sure, bye.
Bye. Yes, and then those are the realities of my day as I was attempting to show you these particular things that come with doing court matters that are urgent. You must understand that I am on duty 24/7, and you must understand the reality of the matter to be as real as the law that is also in operation 24/7 in our country. And these are the things that I am doing, and these are the things that I am engaged on. And then unfortunately, since morning today, I have not eaten. I have forgotten because I have had to review the drafting of the document, and then having to come to the reality of filing that particular document which gave rise to this particular call, and then to just take you further in this particular matter. It is an issue where that call is coming from the SABC. Will come back from this particular scene. Let us just only do these things. Let's leave you. This comes from this particular email, where in which Basanda was responding to say, please be advised that we are no longer acting for the South African Broadcasting Corporation in the matter. Kindly serve them directly and omit us from any further correspondence herein. Regards. And then I tried calling him on this particular cell phone number, and that was when he responded to this particular call immediately as I went live on this particular video. It is in this matter where I have sent the notice of set down for tomorrow, and then it is in this matter where I have sent an appeal of vexatious order, and then where I have sent the draft order in that particular regard. And then I will take you through these particular documents. Before I take you through them, I want you to understand something here. By this action that I have done, I have basically fulfilled the obligations imposed in terms of section 18.5 of the Superior Courts Act by actually lodging this particular matter. And then in lodging this particular matter, it is an issue where now this particular case number, as you can see there, is suspended pending the hearing of this particular matter or the conclusion of this matter. So there, one have said to the Registrar of the Higher Western Cape High Court, good day, kindly find attached notice of motion to rescind the order by Davis J in terms of section 18, read with section 19A of the Superior Courts Act as directed by Judge President Hlophe on the practice directive issued on 10 August 2020. In relation to appeals, the Judge President wrote the following under applications for leave to appeal. All applications for leave to appeal, including requests for reasons both civil and criminal, shall be heard or dealt with during the lockdown period in terms of section 19A of the Superior Courts Act and as envisaged by paragraph 13 of the directives issued by the Chief Justice on 2nd May 2020. Applications for leave to appeal must be issued and filed at the court as well as emailed to the relevant judicial officer's secretary. The registrar's office will arrange for the file to be delivered to the judicial officer. Judicial officers should utilize Microsoft Teams, Zoom, WebEx, or the likes as an alternative to oral submissions in open court so as to eliminate the need for practitioners to attend court. The application is in terms of section 18 of the Superior Courts Act as a result of the irreparable harm endured. Hence the urgency of the matter and the request that it be enrolled as an urgent action to be determined in terms of section 19A without hearing the parties. I trust you now understand that I have acted in terms of section 18.5 of the Superior Courts Act and lodged an appeal when you receive this email. Therefore, the operation and execution of the order is suspended pending the conclusion of the appeal with this self-evident truth. There is no legal impediment hindering me from making any application that may be decided by the application of law. I will ask Mrs. Bernadette Berger as the Secretary to kindly notify all in terms of this email if Judge Parker will be Pangaka will be handling the attached matter in accordance with its terms or not, and that if the judge is available to urgently hear case number 19275 of 2020. It is not my wish to have case number 19275 of 2020 move from one judge to the other without being heard, and request the registrar to ensure that the matter is heard in accordance with the notice of set down attached hereto. I will see the parties in court at 11:15 before the matter is heard at 11:30 on 26 August 2021. We must agree on the timetable to file other papers from the defendants. It is only fair when considering that the defendants face imprisonment for life upon conviction of torture. I understand and appreciate all effort taken to uphold, defend and respect the Constitution as the supreme law of the Republic in the interest of justice. Regards. And it was sent from my email, it was sent to the following parties. These, for the record of this video, these are the parties that have received this particular matter. And I have been true to all of you. Let me just only take you to the notice of set down for the matter that we were dealing with. That is the matter between Lieutenant Commander Sylvester Volane Mangolele, which is the plaintiff, and the state is the first defendant, the president is the second defendant, the minister of defense, the third defendant, the chief of the South African Navy is the fourth defendant, the officer in charge, Lexato Cape Town, that is Colonel Mandela, is the fifth defendant. And Mr. Marcel Divet is the sixth defendant, and Minister of Police Bheki Cele is the seventh defendant. And the National Prosecuting Authority is the third party. A notice of set down where you will be pleased please place this matter on the roll for hearing on 26th day of August 2021 at 11:30 or as soon thereafter, as counsel may be heard under the following circumstances. The matter was not heard on 24 August 2021 at 10:00. A notice of motion to rescind the order by Davis J issued on 14 September 2018 is filed with the registrar in terms of Section 18 read with Section 19A of the Superior Courts Act. Therefore, the execution and operation of the order is suspended pending the conclusion of the appeal, and there is no lawful impediment restricting the court to make a just and equitable order limiting the retrospective effect of the irreparable harm endured by the plaintiff. The plaintiff is required at home in Hammanskraal, and payment of his salary is required for him to attend to the 83-year-old grandmother who is terminally ill and has not seen the plaintiff since spending 202 days in prison as a result of malicious prosecution. To the registrar, kindly set down the matter in accordance with the above information. The matter was dated today and signed by myself and sent to the registrar of the High Court and then to the State Attorney to the National Prosecuting Authority. This is a matter that was supposed to have been heard yesterday, but it was not enrolled. And now we have here an index of case number 15141 of 2018, in which myself am the appellant, the Minister of Defense is the first respondent, the South African Human Rights Commission is the second respondent, the South African Broadcasting Corporation is the third respondent, Cell C Propriety Limited is the fourth respondent, wherein an index includes the notice of motion from page 1 to 3, and then the appellant's practice note from page 4 to 5, the accompanying affidavit from page 6 to 11, appellant's heads of arguments from page 12 to 17, and SVM 1 appellant's constitutional address in page 18. The list of authorities that have been employed in this particular matter is the Practice Directive of the Western Cape High Court Access to Court in light of COVID-19 lockdown from Judge President Hlophe to all judges. Implementation date was 10 August 2020. Vexatious Proceedings Act 3 of 1956 is an authority being used. The Constitution of the Republic of South Africa Act 108 of 1996 is the authority being used. The Defence Act 42 of 2002 is one of the authority relied upon. Prevention of Combating and Torture of Persons Act number 13 of 2013 is one of the authorities. Judicial Code of Conduct is another authority cited in these proceedings. Investigating Directorate, Serious Economic Offences versus Hyundai Motors Distributed Property Limited in Hyundai Motor Distributed Limited versus Smith, number 2001, open brackets 1 close bracket SA 545 at the Constitutional Court at paragraphs 23 and 24. Is authority relied upon on this particular matter. Makate versus Vodacom, by the Constitutional Court in 2016 at paragraph 87 is another authority relied upon on this particular matter. Daniels versus Scribnet and another in 27 by the Constitutional Court is another authority relied upon on this matter. And Navatis and Mafil and Warrior Holdings Limited versus Stalwell Limited and another of 2009 is another authority relied upon on this particular matter. And this is the draft order to the order that is being sought for the application to be enrolled as an urgent action in terms of Rule 6, and then for the order issued against the appellant on 14 September 2018 in terms of Section 21 C of the Vexatious Proceedings Act 3 of 1956 is rescinded, and that the respondents must pay the cost. And now, I want you to understand the reality that goes into working and compiling these particular documents. Fellow South Africans, it is a reality that I live, it is the reality that I perform for you in service and defense in accordance with the Constitution and the law. All that is required is for an erudite judge to apply their independent mind without the influence of other persons, and then get to the bottom of this particular matter. There is no truth that says Mangolele is otherwise in mental state or what. I am what you see. I am acting in accordance with the Constitution and the law, and I am doing so diligently. So people who do not follow or obey the Constitution and the rule of law, who do not act diligently in their mandate, are the ones that are crazy. Do not believe them when they tell you, no, Mangolele is a 6'4", Mangolele is crazy, Mangolele wahlanya, Mangolele is stubborn, Mangolele does not listen, Mangolele, just simply because they are busy abusing their respective authorities to ensure that they maintain the sustenance of the criminal activity, corruption and misconduct on my name. Fellow South Africans, this must come to an end. And it is being brought to an end in accordance with this appeal, wherein the parties were already informed to you, and there it says, take notice that Sylvester Volane Mangolele, hereinafter called the appellant, there is the appellant, will in terms of Section 18 read with Section 19A of the Superior Courts Act, make an urgent application to be decided before or on Thursday 26 August 2021 at 11:30 or as soon thereafter as the parties may be virtually heard, as may be directed by the court if necessary, for an order in the following terms. Enrolling this application as an urgent action, dispensing insofar as is necessary with the forms and services provided for in the Uniform Rules of Court in terms of Rule 612A. Rescind the order issued against the appellant on 14 September 2018 in terms of Section 21C of the Vexatious Proceedings Act of 1956. And respondents be ordered to pay cost. The accompanying affidavit of the appellant will be used in support of this appeal. If you intend opposing this application, you must file your answering affidavits, if any, with the registrar of this court, notice of your intention to defend, which shall set forth the grounds of defense to the said claim, and notify the appellant at lingualisto@gmail.com within 2 hours after being served for the matter to be ripe. If you fail to file and serve as aforesaid, Judgment as claim may be given against you without further notice to you. It was signed today, and that is the notice that is in motion. I have seemingly lost connection with the internet, and then I will bring myself back to this particular reality, where we go straight now from where this particular matter is sitting. What is it? Appeal, vexatious order. I was in page that. I'm just opening this particular document, and then I have seemingly lost internet connection in this particular regard, and then the rest of the people will then follow this video on YouTube, because I could not preview that. That is the nice thing about understanding these things when you do them. And now I am looking for this appeal. Where is this appeal? I am looking for that, and that it is there now. And let's make it bigger. There are one too many things that are happening in my computer and are displeasing to the broadcast, and it's okay, it was restored. Maybe it will be in delay a little, as you can see here. Good, then we are therefore again back live on air. And while we do that, we are going to have the original document of this particular notice of motion, and you will be able to see for yourself the realities that goes into making these court documents to come to life and then to be heard in the court of law and be adjudicated accordingly. So we finished the first 3 pages where you saw the notice of motion, and we will go back to that right now. And then after the notice of motion, you are compelled by the rules governing agency to make a practice note. In a practice note, it gives a brief indication of what is the matter all about, and then what is all those particular things that are pertaining the matter in brief detail. And the matter is set down for rescission. Requirement for hearing, I said no, the matter can be determined without hearing in open court. If so, the matter may be heard virtually by agreement of the parties. And legal representatives is self-representation, and the issue is the appellant was not heard or granted an opportunity of being heard before the order was granted as obligated in terms of Section 21B of the Vexatious Proceedings Act. That is the only issue to be considered in this particular matter. Any outstanding matters is case number 19275 of 2020 that was not heard yesterday. The possible settlement of this particular matter is the rescission of the order issued on 14 September 2018. The agency briefly described in this matter is that the appellant is tortured and suffers irreparable harm. The respondents shall not suffer any irreparable harm if the court rescind the order as prayed. Any other information is that the operation and execution of the order is suspended pending a decision of this particular matter. And the accompanying affidavit of this matter is where the undersigned as myself do hereby make an oath and say, I am an adult citizen of the Republic of South Africa with ID number that, aged 38, and a volunteer in the South African National Defence Force, hereinafter referred to as the SANDF, with force number that, at the South African Navy, St. George's Street, Naval Dockyard, Simonstown, 7975. The facts herein are true and factual. The court order issued on 14 September 2018 is unlawfully and intentionally misrepresenting the statutory terms of Section 21B of the Vexatious Proceedings Act 3 of 1956, as the undersigned was never heard or given an opportunity of being heard before making the order. The undersigned was in Pretoria High Court and not in Cape Town when the matter was heard. It is therefore submitted that the order is not in terms of Section 21B of the Vexatious Proceedings Act. The undersigned is obligated not to obey a manifestly illegal order and is tortured for upholding, defending, and respecting the Constitution as the supreme law of the Republic. The order unlawfully declaring the undersigned as a person who has persistently and without any reasonable ground instituted legal proceedings in any court or in any inferior court, whether against the same person or against different persons, vexatious litigant in other words, only sustains the criminal activity, corruption, apartheid, and misconduct on the Department of Defense payroll system, misrepresenting the undersigned as a person convicted to imprisonment for a period not exceeding 5 years. While the reality is that the undersigned was never convicted to imprisonment as obligated in terms of Section 105 of the Defense Act 42 of 2002, as unlawfully and intentionally misrepresented in the DoD payroll system on 8 August 2018, causing the undersigned to be without salary for the past 36 months. The undersigned is tortured and humbly prays to the Honorable Court to maintain an independence of mind in the performance of judicial duties by taking all reasonable steps to ensure that no person or organ of state interferes with the functioning of the courts and at all times, also in relation to extrajudicial conduct, comply with the law of the land as obligated by the Judicial Code of Conduct. By operation of law, the undersigned submits that the operation and execution of the order is suspended pending the decision of case number 19275 of 2020, which is not heard since inception on 30 December 2020, after being lodged with the registrar in terms of the rules as obligated. On a balance of probabilities, the undersigned suffers irreparable harm if the court does not so order as prayed for on the notice of motion, and the other respondents will not suffer irreparable harm if the court so orders. The urgency of this matter is an all-encompassing national security condition in which, as a citizen of South Africa and a volunteer in the South African National Defence Force, the undersigned is homeless, tortured, enslaved, impecunious, live without freedom, peace, and safety, unable to participate fully in the process of democratic governance, deprived enjoyment to protection of fundamental rights, including unlawful and intentional denial of his parental responsibilities and rights, without access to resources and the basic necessities of life, inhabiting an environment which is detrimental to his health, well-being, and bodily integrity. Arbitrary or without just cause, deprived of salary since 8 August 2018. Presumed guilty until proven innocent, and unlawfully and intentionally deprived security of land and tenure. As of paramount importance, The court must consider the best interest of the undersigned's children in relation to payment of his salary and the reality that each time the court refuses to be independent and subject only to the Constitution and the law, which they must apply impartially without fear, favor, or prejudice. Criminal activity, corruption, apartheid, and misconduct is unlawfully and intentionally sustained with impunity. The undersigned cannot be blamed and caused to suffer as a result of an act or omission of the Honorable Davis J. to act diligently as obligated in terms of Section 21B of the Vexatious Proceedings Act, and hear or grant the undersigned an opportunity of being heard before making the order. To keep on sending the undersigned up and down and from one judge to another does not change the fundamental fact that he was not heard or given an opportunity of being heard on 14 September 2018 by Davis J. before making the order. Let us stop South Africa from babysitting criminal activity, corruption, apartheid, and misconduct on the name of the undersigned. To persecute the undersigned and expect him to live a lie that he was heard or granted an opportunity of being heard before making the order on 14 September 2018 is inconsistent with the Constitution and is invalid. In the performance of judicial duties, the Honorable Davis J. did not refrain from being biased or prejudiced, and give special attention to the right to equality before the law and the right to equal protection and benefit of the law. I admit that this is extremely painful to write so many terms and do so much research of law just to convince another human being to see that the Honorable Davis J. did not act diligently. It is extremely painful to remember the savage road in which I am condemned as security of the Republic just to protect a few engaged in criminal activity, corruption, apartheid, and misconduct. I demand an end to this vexatious litigant matter, as it has caused many fellow South Africans, especially my children and entire family, irreparable harm. This fraudulently obtained court order played a significant role in directing people to unlawfully conduct in the name Sylvester Volane Madala Mangolele to a point of unlawful detention for 202 days at Paulsmo Medium A prison based on allegations of trespassing, which is a non-arrestable offense in which the accused person cannot be detained while awaiting trial. The notion that a person cannot represent themselves in court and win is what had blinded many judicial officers, that when any person reads Section 21C of the Vexatious Proceedings Act 3 of 1956, such person will find that the court may at any time on good cause shown rescind or vary any order so issued. By simply applying the law, my children will be with their father, my family, country, and its people will stop suffering. Criminal activity, corruption, apartheid, and misconduct shall be effectively dealt with, and the supremacy of the Constitution and the rule of law upheld, defended, and respected. The continuously ignored reality is that there is no right in the Bill of Rights that can be respected, protected, promoted, and fulfilled in a constitutional address attached here to marked SVM1. And SVM1, coming back to page 9, SVM1 is this particular reality. This is the constitutional address in which no right in the Bill of Rights that may be protected, promoted, fulfilled, in this particular matter. This is a painful reality. One is expected to shower here, one is expected to sleep here, one is expected to cook here, one is expected to raise their children here, one is expected to do everything that must be done by any other ordinary human being to be done here. This is the action that has been taken. This is the action that must be corrected in accordance with the Constitution and the law. To continuously say Mangolele, go away as you have done in the past, is to persistently maintain this constitutional reality. I demand the reinstitution of my fundamental human rights. It starts with rescission of the fraudulently obtained court order whose judgment does not exist. It was just an exercise between a judge and counsel who violated the code of judicial conduct and hide behind power. Let there be peace in my life. Let there be justice for all. As a natural person, this court order has impugned on my reputation and dignity as a person. It has destroyed my family as a result of sustaining my aggravating circumstances. The future of my 2-year-old daughter Aluta Songelwa to a normal childhood is destroyed by the fraudulently obtained order, causing irreconcilable differences between mother and father of an innocent child. It is submitted that this court order actively sustains criminal activity, corruption, apartheid, and misconduct in critical capabilities of state. Against all odds, I have kept the faith in the supremacy of the Constitution and the rule of law. I have written this application crying in tears, thinking of my 83-year-old grandmother who is severely affected by this matter to a point of not wanting to hear anything about it, thus causing her to bury me alive in her thoughts. The depth of the pain and suffering caused by this order is sickening to any person who knows Sylvester Volane Mangolele as a person who upholds, defends, and respects the Constitution as the supreme law of the Republic. This is the founding affidavit of this particular matter, and this is what the court must consider. And in considering this particular matter, the court will have to take into account the heads of argument, where it explains this action as an action for rescission in terms of Section 21C of the Vexatious Proceedings Act, from a division committed to deliver transparent, efficient, and quality access to justice for all. Section 21C of the Vexatious Proceedings Act reads, an order under paragraph A or B may be issued for an indefinite period or for such period as the court may determine, and the court may at any time, on good cause shown, rescind or vary any order so issued. And the practice directives of the Western Cape access to court in light of COVID-19 lockdown from Judge President Trope to all judges, implemented on 10 August 2020 on page 1, highlights the fact that the Western Cape Division is committed to deliver transparent, efficient, and quality access to justice for all. And if I may show you that, on page 1, without any reasonable doubt, this is the statement that actually says that. It is for you, the viewers. The judge would know this like a back of his hand, and the viewers, you will know this as this access to court in light of COVID-19. I have appreciated that. That is me respecting the rules of court, and then that is me highlighting to you everything that I have done in this particular regard. Let me bring this to here. So now you understand the origin of this particular appeal. And then when we go to the Vexatious Proceedings Act, terms of section 21C, it is how you write it. Section 2, there's the Vexatious Proceedings Act 3 of 1956, section 21C of it. There it is, as it is written in this particular appeal. So it is not that I am robbing a judge. It is not that I am trying to fool a judge or being clever to a judge. I'm just only summarizing matters and circumstances to the judge, so that the judge, as a learned person, can be able to tell without any reasonable doubt that, okay, this person has done his homework. I do my homework. I do act diligently in accordance with the Constitution and the law, and I do hear myself each time I say each term that I mean. And fellow South Africans, this is basically how the dice indica in terms of section 18 is 2 hours. The only factor to be determined by court is whether the appellant was heard or granted an opportunity of being heard before making the order on 14 September 2018 as obligated in terms of section 21B of the Vexatious Proceedings Act of 1956. Section 21B, fellow South Africans, it shows you here, like I have showed you many times, that the court may, after hearing that person or giving him an opportunity of being heard, order that no legal but that order must come after hearing the person. So when we talk about it is, did you hear me before making the order to comply with this particular terms of reference that you have made? You understand? So I am exact, I am precise, I am on the point when it comes to law, when it comes to everything that I say to you, and when it comes to the execution and operation of law. So, good people, that is how these things are done. Why must the appellant be the one who suffers as a result of inaction by statutory bodies employed to respect, protect, promote, and fulfill the rights in the Bill of Rights? It must be remembered that the state is, in terms of section 7(2) of the Constitution, employed to respect, protect, promote, and fulfill the rights in the Bill of Rights. And when it comes to law, this matter is in terms of the powers of court to impose restrictions on the institution of vexatious legal proceedings provided for in terms of section 21B of the Vexatious Proceedings Act. And again, I show you, this is what section 2 of the Vexatious powers of court to impose restrictions on the institution of vexatious legal proceedings. Do you see that? I did not take things out of my own mind. I just only simplified them for any other person who is reading this thing to understand it the way it is. Obligating that if on application made by any person against whom legal proceedings have been instituted by any other person, or who has reason to believe that the institution of legal proceedings against him is contemplated by any other person, the court is satisfied that the said person has persistently and without any reasonable ground instituted legal proceedings in any court or in any inferior court, whether against the same person or different persons, the court may, after hearing that person or giving him an opportunity of being heard, order that no legal proceedings shall be instituted by him. Good people, this is basically a direct copy and paste of what the law says in terms of section 21B of the Vexatious Proceedings Act. The appellant is obligated in terms of Section 1996 of the Constitution, Act 108 of 1996, read with Section 2E of the Defence Act 42 of 2002 and the Code of Conduct for uniformed members of the South African National Defence Force not to obey a manifestly illegal order. Section 3A 2 and 3 of the Prevention of Combating and Torture of Persons Act number 13 of 2013 reads, for the purpose of this act, torture means any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted upon a person for such purposes as to punish him or her for an act he or she or any other person has committed, or intimidate or coerce him or her or any other person to do or to refrain from doing anything. And Section 12(1)(d) of the Constitution imposes an obligation that everyone has the right to freedom and security of the person, which includes the right not to be tortured in any way. The guiding light for interpreting statute is Section 39(2) of the Constitution, which requires that all persons interpreting any legislation must promote the spirit, purport, and objects of the Bill of Rights. As the Constitutional Court put it in McCarthy v. Vodacom, Section 39(2) means that the courts are bound to read a legislative provision through the prism of the Constitution. In Hyundai, the Constitutional Court held that judicial officers must prefer interpretation of legislation that fall within constitutional bounds over those that do not, provided that such an interpretation can be reasonably ascribed to the section. Ascribing this matter to the provisions of Section 4 of Prevention of Combating of and Torture of Persons Act, the order issued on 14 September 2018 tortures, incites, instigates, commands, or procures any person to torture the appellant or participate in torturing the appellant, and it causes conspiracy within public officials to aid or procure the commission of or to commit torture against the appellant. As the appellant is intentionally inflicted with severe pain or suffering both physically and mentally for such purposes as to punish him for an act committed by Davis J., and is intimidated or coerced to do or from doing anything as a result of this order. In Daniels v. Scribante, the Constitutional Court emphasized that courts must adopt a purposive interpretation that is compatible with the mischief being addressed by the statute concerned. That means that a court must determine the goal of a statute as a whole and of a particular provision and seek as far as possible to interpret the legislation to further that goal in the specific context of Section 25(6). The court held that, with all this background in mind, the mischief that Section 25(6) of the Constitution and ESTA are seeking to address is not far to seek. Addressing the mischief is not only about securing the tenure of ESTA occupiers. It is also about affording occupiers the dignity that eluded most of them throughout the colonial and apartheid regimes. We must adopt an interpretation that best advances this noble purpose for Section 25(6) and ESTA. This is as in the matter of Daniels v. Scribante, heard by the Constitutional Court on 2017 at paragraph 24. In context, it is trite that most words can bear several different meanings or shades of meanings, and to try to ascertain their meaning in the abstract divorced from the broad context of their use, is an unhelpful exercise. Or as Lewis, acting justice, pithily put it, that words without context mean nothing. The obligation to consider context is required by the Constitution. Context, as Moseneke, Deputy Chief Justice, explained, includes two elements: the social and historical background of the legislation and the grid of related provisions and of the statutes as a whole, including its underlying values. The plaintiff's unique circumstances must be interpreted against the historical background, devaluing customary rights and freedoms. By simply taking action to lodge an appeal, as is the case, the operation and execution of a decision which is the subject of an application for leave to appeal or of an appeal is suspended pending the decision of the application or appeal. It is in this event when any erudite judge may consider the actual reality of the action taken by the appellant. The court must not prejudice the appellant by sending him from pillar to post, while the reality will still remain that the appellant was not heard or granted an opportunity of being heard before making an order on 14 September 2018. It is indeed true that the appellant did take lawful action against the misrepresentation on his name, and his claim that this matter is driven by personalities is not application of law is true, as when one applies the law to the latter as obligated in terms of Article 6 of the Judicial Code of Conduct, the appellant's aggravating reality would not exist. In conclusion, the multicultural nature of South African society calls for special sensitivity for the perceptions and sensibilities of all who are affected by court proceedings, and a judge must take reasonable steps to enhance the accessibility of courts and to improve public understanding of judicial proceedings. And unless special circumstances require otherwise, conduct judicial proceedings and make known his or her decision and supporting reasons as obligated in terms of Article 7 read with Article 8 of the Judicial Code of Conduct. There is no written reasons or judgment granted by Davis J. on the matter, causing the function of the judiciary to fail, as the legitimacy of the judiciary depends on the public understanding of and confidence in the judicial process. A judge is obligated to avoid unnecessary discussions in chambers, i.e., with the legal representatives in the absence of parties, of matters that may be relevant to the merits of the case, and if what has happened in chambers has any effect on the proceedings, those facts are to be placed on record in open court. See Note 8.4 and Note 8.5 of the Judicial Code of Conduct. Now, any erudite judge may ask, on what lawful grounds was the order issued in terms of Section 21B of the Vexatious Proceedings Act? No matter the direction that may be given as in the past in relation to this matter, the primary and fundamental fact that the appellant was not heard or granted an opportunity of being heard before the order made shall not change. Therefore, the order issued on 14 September 2018 does not hold the force of law, and in any event, it does not promote the spirit, purport, and objects of the Bill of Rights. The very obligation is convenient in this regard if a provision is reasonably capable of two interpretations. Section 39(2) requires the adoption of the interpretation that better promotes the spirit, purport, and the objects of the Bill of Rights. This is so even if neither interpretation would render the provision unconstitutional. In the premises, I pray for rescission in terms of Section 21C of the Vexatious Proceedings Act, and that the respondents pay cost, as it pleases the court. This concludes this particular matter, and in concluding this particular matter, this is what now I await from the judge, and including the phone call from the attorney of the SABC. This matter took an hour, and when reading this matter, a speed reading judge would basically take 15 minutes to read this matter. That's how fast the judges read this matter. And then in conclusion of this matter, fellow South Africans, I await the decision of the judge in terms of Section 19A of the Superior Courts Act, which allows the judge to make a decision on the matter without hearing the parties, and the judge is allowed to call all parties when necessary, either via Microsoft Teams or via this thing. In fact, to make it easy for you, let me show you in accordance with the rules, so that I don't have to repeat what Judge President Hlophe has issued in terms of the rules of his court during lockdown COVID-19. I will take you directly to the rules and show you the page of the rules, and then cement this particular matter for you to understand the reality that awaits any erudite judge that must make this matter in terms of the Constitution and the law. And the rules are as follows. You go to the rules. These are the rules. Office of the Judge President, Western Cape High Court. He made this particular access to court in light of COVID-19 lockdown, issued on 10 August 2020 to all judges. So all judges in the Western Cape must abide by these practice directives. That is the duty of the Judge President, to direct the proceedings and to direct the proceedings of court daily without influencing the independence of the judges. And this is how it's done. Applications for leave to appeal. All applications for leave to appeal, including requirements, as I have read on that particular email, here says the judicial officer should utilize Microsoft Teams, Zoom, WebEx, or the likes as an alternative to oral submissions in open court, so as to eliminate the need for practitioners to attend court. So effectively, I await a call from either the registrar of the court or the judge concerned in relation to this particular matter, wherein now a conclusion of this matter will be put to bed. Tomorrow at 11:30, I am meeting counsel in court in accordance with this other case number that was not heard yesterday, and that particular matter needs to be ventilated in the record of court. And if the judge so directs wanting it to be ventilated, otherwise I shall take direction from there. Other than that, fellow South Africans and everyone in the world, have a good night. Papa O Teng.